Gaiety.
Lord my lady, I bring initially rather sad news, which is that my colleague, Mr Edwards, who would in the ordinary course of things have taken the lead on advocacy this morning, has been taken ill overnight and is, as I speak, awaiting blood tests to confirm that he has in fact had appendicitis.
Oh dear.
Oh dear.
Well, we're all sorry. I'm personally sorry because I know him well. Please pass on our very best wishes. It would be insulting to ask you whether you're ready to address us. Of course you are, because you have a deep and abiding knowledge of the subject. So thank you very much.
Thank you very much, my lord. I became aware of the need to address you this morning at 9:20. But of course I'm delighted to be here, and I've already, you've alluded to the fact that I'm also professor, my lord. I've already relied on the other side, as it were, to assist me if there are any moments of procedural ineptitude displayed by me. So,
sure there will.
one preliminary matter we both wanted to clarify, Mr. Bramasev, is as to how long you anticipate that this case will proceed. We think, Mr. Bram, my learned friend, we think it's a day, don't we? We think it's a day. Is
Well,
that...
it's only been given a day.
Yes, no, we didn't intend to spill over.
Both sides will have to be quite concise. I imagine that you would expect to finish your opening address at the lunch break, and that will give time for Mr. O'Brien to address us this afternoon and for you to reply.
And there's Mr. Ford.
Oh yes, I'm so sorry. Yes. Yes. Have you?
Yes, I'm instructed by the Metropolis police, and I don't expect to play much, if any, a part in these proceedings. As you know, we adopted a neutral position below.
Indeed. I'm so sorry. I had noted that the Met was adopting a neutral stance, and there isn't a skeleton from yours. That's a relief. Well, if there's anything that you would like to say at the appropriate moment, then of course we'll hear you. But I imagine we'd be talking about 5 minutes or so, if that. Yes. Right. Professor.
Yes, the absence of a skeleton came as something of a relief to me as well. At about 9:45.
With your speed reading.
Yes.
And also the confusion arose, I think, because originally it was thought that this had been listed for only half a day. But we're expecting a day.
Yes, please. Thank you very much. That's good for us to know. Essentially, we initially, as you will be aware, and it's in the core bundle, we had a number of grounds of appeal against the judgment of Mr. Justice Fordham, which is in the bundle, and to which I will, of course, return. And we have, with the agreement of all sides, narrowed down the issue. So that should, we hope, assist the court.
Yes.
And the narrowing down, if we go to the core bundle at page 235, I've got somebody to help me with the computer, my lady, just sitting on my side here in order not to delay matters.
Yes.
We will see if you could just...
Well,
you've got it.
This is the, we have got
You've
it, and this is the note which says that you are limiting yourselves to ground 1, Article 12, and you're not pursuing the second ground relating to Articles 8 and 14.
Correct.
Yes.
And the Article 12 issue, therefore, being central, is covered in our skeleton argument, but we are not relying on the other dimensions to the argument. And if we go to Article 12 as our starting point, therefore, we find it in the bundle of authorities at page 200, I think. I'm right.
Yes.
And I'm just getting it. And we see it here as men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. Short, and I didn't want to paraphrase it, my lords, my lady, but easy to absorb and set out for our assistance there. I make 3 preliminary points about it as we delve into analysis of this article. Firstly, it is in its own way a positive right. So it requires state action in order to marry. It's not the equivalent of, for example, a right not to be this or a right not to be that, tortured, killed, or whatever. So that's my second point. It's not a negative right. It requires national action to make real, which is, of course, anticipated in the provision. Critical to our argument as it unfolds this morning is that it is not analogous to Articles 8, 10, 11, which explicitly permit exceptions where these are necessary in a democratic society. Now, do stop me, my lords, my lady, if I'm going too fast, but essentially the gateway to proportionality in the scheme of the European Convention on Human Rights is via, primarily, not exclusively, the term necessary in a democratic society. The term proportionality does not exist in, and is not to be found in, the text. But there are various ways in which it infiltrates. And the explicit infiltration is absent in Article 12. The explicit infiltration is where exceptions are permitted, where they are necessary in a democratic society. It also infiltrates, if I may say so, not in an ominous way, articles such as Article 14, which it does not have the necessary democratic society dimension to it, but which has been, in a completely sensible and rational way, read as embracing a test of proportionality. The same with the right of access to a court. Article 12 does not have this. And my essential argument going forward will be that it's got a particular and specific role in the context of Article 12, which is subsidiary to a primary question. Which primary question governs Article 12 in a way that it governs no other articles. I'd be so bold as to say no other articles. And that is the test of the breach of the essence of the right. It's regarded by the court, these remain my preliminary remarks, an important, serious, fundamental right reflected in the unambiguity of the language. So we say, my lords, my lady, we say 3 things. I'm going to argue 3 propositions. Firstly, and apparently from an advocate's point of view on appeal, counterintuitively, we say Mr. Justice Fordham laid out the Article 12 law correctly, comma, initially. We say, and I'm going to take you, if I may, to the judgment, we say he got a lot right. And we adopt, I'll do it explicitly, but we adopt much of the reasoning. So our first point might seem counterintuitively against us. But we then say, and this is a core point we make, that he conflated the second of our 3 points. He conflated Article 12 with the other articles in the Convention. That he moved from his clear analysis of Article 12 to a clear analysis of Article 14 and Article 8, and he got ensnared, understandably, in the world of justification and proportionality. And we say, the tail, as it were, of these justificatory criteria applicable to other articles, as it were, to deploy an inappropriate metaphor, wagged the dog that is Article 12. And we say that that was an error of law. I will deal in reply, if I need to, about whether or not we should be here on this. It seems to me a straightforward appeal point. He misapplied the test in Article 12 and, as a result, made an error of law. We say thirdly, that if he had applied the law as he might have done midway through his judgment, and if he had applied the law that we say should have been applied, the Article 12 tests, and again it's on essence, and we return to that, we say he would have found for us. So we say, firstly, there was a good application of Article 12. Secondly, there was a confusion which caused him to make an error of law in his application of Article 12, which was subsumed within a wider analysis. And thirdly, that had he applied the correct test, we'd have succeeded in our case. Because our argument will be that the essence of Article 12 was transgressed by the action in depriving, or threatening to deprive rather, two of our claimants of their pension in the event of their remarriage. Indeed, my lord.
Clarify before you move on to the individual arguments. So you're saying that the question is whether the essence of Article 12 is interfered with, breached, how one puts it, and that if one finds that, then one doesn't go on to consider any question of proportionality in the traditional sense.
It's certainly not in the traditional sense, and I'll take my lord and indeed my lord and my lady later to the case law.
I understand that. I just
yes,
at some convenient point.
No,
this may not
that
be
is
it.
correct. That is correct.
I want to understand whether you're saying this is really just a one-stage process, or whether you're accepting that it is a two-stage process, although of a different character.
I'll slightly, if I may anticipate that, and revert. I'll return to it, but I'll anticipate it now. We say that the first question is, has the essence of this right been adversely affected, damaged? And we say, if the answer to that question, in relation to any right, is yes, it has been. It has been eroded. The essence has been affected. No proportionality test can save the departure from the right.
Right. So that's what lies behind your second preliminary point about getting ensnared in justification and proportionality.
Correct. Directly correct.
Right. So that also explains why you're content with the way in which the ground which you do pursue is framed, which is a one-stage argument rather than a two-stage argument.
I think the logic of our position is that you ask a question about essence, and if you find that the essence is not damaged, then you say, carry on. I'm not sure that we're arguing strongly that despite the essence not being damaged, there is nevertheless an argument from us that it's disproportionate. I don't believe that that argument is effective with regard to Article 12. I think, if I may just, I may just complete the point, if I may. With regard to other articles, what they do is they say, is the essence of Article 8 affected by X? And they say, it jolly well is. And then they say, well, there's no circumstances in which proportionality can save this action because the essence of the article has been affected. Our article is different. So if you, for example, fought off an argument on essence with regard to Article 8 or Article 6, or you then move into phase 2, which is that you might still win on proportionality. I'm pretty content to say that we are looking at a singular test. Has the essence of Article 12 been damaged, eroded, breached? I'm not arguing, I think it would, if I may say, it would be unrealistic to argue, that, now, the essence has survived. My lords and my lady find that. But nevertheless, we think it's a disproportionate interference with the right to marry. I think that's unduly complicated, and I think it undermines my argument about the specific and special nature of Article 12. So I'm not, as it were, trying to have my cake and eat.
And I'm sure you'll come to this, but therefore, what will you say, or are you going to say, about what the judge describes as the composite test?
Yes, I am.
And I just, when you come to it,
yeah,
I'd like that put into this context, because it seems as if Mr Edwards proposed the composite test, which was then accepted by Mr O'Brien, and that's why it runs through the judgment.
Yes.
And I just need to see how that fits into what you've said.
Yes.
And I'm sure you will come to that.
I will come to that, and anticipating slightly, I'm not sure I'll be immensely defending the composite test here.
I didn't think you would.
There are advantages to appendicitis. We'll get to it, my lady, and remind me if we don't.
I will.
So we've got this 3-part journey, and the first part is where I'm a fan of Mr Justice Fordham. We're fans of Mr Justice Fordham. We think, if I may take you, he's in the, I think it's the core bundle, isn't it? Pages 53 to 106. I've got a printed copy of the judgment here, and I may well refer to paragraph numbers.
Yes.
But you will have, I'm sure, seen the judgment. So, I take you to paragraph 37 of this long, careful, meticulous judgment, which nevertheless, we say, was in error. And we see him setting out the Article 12 cases. And his method is to deduce general principles from the Article 12 cases. And since they are so central to my argument, and since I am at this point supportive of the analysis, I want to take you to it. Not for long, but take you to it. Because we see in paragraph 38 the reference to the really strong case on this area in UK law, the Bayi case. Apologies for the almost certain mispronunciation. And we see on paragraph 38, towards the end, we see that Mr Justice Fordham has very helpfully set out propositions which he has deduced from a very close reading of this case after argument. And these propositions identify the specific nature of Article 12. And they're set out as a number, I think 7 or 8, 9, not all relevant to us. But the first bundle are, if you see midway down paragraph 38, the right to marry in Article 12 is a strong right, described as fundamental. You will be aware of the origins of this as concerns about restrictions on marriage being one of the core aspects of pre-war authoritarian regimes, and it had a strong resonance when the convention was being drafted. And then something I've already said, worth repeating from my point of view, there's no Article 12 equivalent of Articles 8 to it cannot be qualified on similar grounds. And then a point we've already mentioned is that I called it earlier a positive right. It requires national law to make it real. It's not like a negative right, that's 3. And then 4 is relevant. A restrictive approach is taken towards national laws governing the exercise of the right to marry. And then making its appearance, anticipating the later argument, we have national laws which impose conditions. This is 5 in paragraph 38. which, quote from the Bayer case, impair the essence of the right to marry, are in trouble. They cannot do that. That's the test. And
those are national laws governing the exercise of the right to marry.
correct, my lord. You're allowed to have national laws. These people have to be, if you remember Article 12, they have to be of marriageable age, you know. So if you have a national law which means that 5-year-olds can't get married, there's going to be no complaints about that. It hardly tranches on the essence of the right. So correct. It's a control on the national laws which are required to make the right real. So unusually, we need laws. We just want to make sure the laws play fair with Article 12. And they must not injure or impair the substance of the right or deprive a person or category of person a full legal capacity of the right to marry. And then I have, quoting again, it's the Bayer case, substantially interfere with the exercise of the right. Now, our case of Bayer is in our agreed authorities bundle. I'm using Mr Justice Fordham's judgment for sort of brevity purposes, but it's in there, and you can match the paragraph references if you wish. And then number 6, not so germane here, germane there. It was to do with third country nationals' right to marry. But there's references in 6 towards the end. Article 12 exists. This is on page 35 now of the judgment as issued, so it's over my page. Article 12 exists to protect the right to enter into a genuine marriage. And then at the very end of this...
I'm sorry, before you go on,
Yes.
in his proposition 6, he's talking about a permissible objective. That is a permissible objective in relation to the substance or procedure of the rules regarding marriage in the national law.
Correct.
And so at some stage, I'm just trying to feed it back into your proposition about there being one test and your rejection of the composite.
Anticipated rejection. I haven't fully done it yet.
Your possible rejection of the composite test. That in fact, one does need to see whether what the national laws are doing impairs, using all those words, the essence of the right. But in doing that, one needs to see whether the provisions of the national law, the procedural, the substance, are in fact furthering a permissible objective.
Yes.
Are you content with
Content
that?
with that. Content with that.
And therefore, to some extent, when you're looking at the national law, you've got to see whether it is inside or outside, whether it impairs the essence, but whether as a facet of that, it has itself a permissible objective.
Yes, my lady.
Sorry to be long-winded.
No, it's good to take the time. And it occurs to me that if, for example, one of my claimants desired to marry somebody whom they'd never met in order to be able to skip past immigration rules, and they'd hit, as it were, the wrong person who needed to go through all of this finagling to get the marriage, then we'd say, look, that's an Article 12 restriction. It may go to the essence of their right to marry, but it's not a real essence because it's not a real marriage. It's a sham. And that was part of the context, I think, in Bay. And the very last bit I was about to mention, number 9, even in the context of identification and prevention of marriages of convenience, which is what I was identifying in response to my lady, the fees would be incompatible if they impaired the essence of the right to marry or unreasonably inhibited the exercise of the right. And then there's a point about fees here. And of course, we may or may not want to pursue it, but is a lost income from a pension the same as a fee? What is the extent of which, how does a financial inhibition to marry need to manifest itself? We say we stick on the question whether it's an unreasonable inhibition. We don't worry so much about whether it's a charge or a foregoing. So that, my lords, my lady, is what Mr Justice Fordham had to say about Bay. It's So it's the main. I would submit it's the main case on this in our jurisdiction. O'Donoghue.
Just,
if I
just,
may-
be-
yes,
just before we leave
yes,
it's obvious that a national law or regulation which says you cannot get married until you have paid a fee of £295 is a law governing the exercise of the right to marry. But are we concerned in the present case with a law governing the exercise of a right to marry?
the later dicta from Mr Justice Fordham, relying on cases to which he refers from within this family of cases, show that and I will need to check to bring you to them, that it's not essential that the law that is being impugned needs to be essentially, specifically, explicitly on the regulation of marriage. So it's not only that the national laws which are called the regulation of marriage laws are vulnerable to be checked for compliance with Article 12. It is, and we would say like our pension scheme here, it is other provisions aimed at other matters more broadly, but which have a direct impact on the right to marry, fall within the concept of the national law.
Yes, I quite understand that your case is that these regulations, specifically C9, impair the essence of the right to marry. If one jumps straight to that, my question in my mind, maybe it doesn't matter, but it's not obviously a law governing the right to marry.
Yes. We say, and I will need to do a little bit of checking and come back to it.
Yeah.
We say that the cases tell us that governing embraces legislation which has the same effect, albeit indirectly, than laws which are, as it were, specifically governing the right to marry. A point which I would say is a fairly logical one in the terms of the interpretation of Article 12.
Right.
If
O'Donoghue.
If I come across it, I'll come across it. But
Of course.
I'll make a note.
Isn't that R and F, or
Yeah.
the circumstances in R and F?
Yeah, something like that. That's
Yeah.
right, my lady. Yeah. O'Donoghue is essentially the same sort of issue. There was a change in the schemes and so on, and O'Donoghue went on a very similar basis to the European Court of Human Rights, and Mr Justice Fordham has it in paragraph 39, and I want to, if I may, go 2, 4, 6, 13 lines down. There's a sentence where he is deducing what he believes to be the relevant and germane aspects of O'Donoghue. Article 12 is the sentence starts towards the end of that line. Article 12 did not involve the permissible grounds of interference seen in Article 8.2 with their accompanying lack of necessity or pressing social need. And then we have national laws governing the right to marry could include formal rules and substantive provisions, but could not, compatibly with Article 12, introduce limitations which restricted or reduced the right to marry in such a way or to such an extent that the very essence of the right is impaired. I'm hoping you're seeing that in the middle of quite a long paragraph 39. We have, I think, there the beginnings of an answer to the point about what kind of law. There's no qualifying observation that the law needs to be specifically about the regulation of marriage. The matter is as to the impact of the aforesaid laws on the essence of the right.
Well, once again, it's laws governing the right to marry. In that passage.
I understand. And perhaps I'll need to...
Because I'm just not sure that the answer comes from that
It doesn't.
particular passage.
I was supposed slightly opportunistically hoping that it might immediately be assumed it did. I think governing needs to be looked at a bit more. I think we're coming to F, and we may find it, and we may even have a look for it or come back to it later. But definitely, my belief in the case law tells us don't, as it were, focus too much on governing in the narrow sense of specifically about, in the broader sense of regulating. But you're right, it doesn't answer the point directly. What I'm taking it to is the emergence of this test of essence again, and the clarity with which the Article 12 case law is pushing us in the direction of essence.
But Professor Geerty, it goes on, doesn't it? Mr Justice Fordham goes on at 39 immediately after where you stopped to refer to state authorities' latitude in Strasbourg terms margin of appreciation. And I assume you're going to fit that in to your landscape about composite question, etc.
I am. I'm going to just take some advice which may be sartorial or about court etiquette or could be substantive. Will you forgive me?
Of course.
I was just going to say.
So my learned friend has just suggested that I do in fact take your hint, as it were, and read, in applying that test, the question was whether, having regard to the state authority's latitude in Strasbourg, quote, the margin of appreciation, the impugned interference with the right to marry was arbitrary or disproportionate. Thank you, my learned friend, for that. And what it introduces, I think, is what I've been not postponing intentionally, but which we're going to have to look at where proportionality fits. And I think I might like to take you through that when we get to essence, because I'll be clear. It's a little bit of a conflation there, to be honest with you.
Oh.
And not by Mr. Justice Fordham, but there is certainly the beginnings of a composite test, and I think the composite test does not assist.
This in the judgment in O'Donoghue.
Yes.
Yes.
In the quote that in the summary of the
Yes.
remarks made by Mr. Justice Fordham, which I do not disown, there is a suggestion. My learned friends kindly invited me to go there, that the essence, let's say, has to be understood in the context of the margin of appreciation, and then not slipped in, that's unattractively negative terminology about something I may view as not entirely helpful. The question of arbitrary or disproportionate.
But are you saying that that's not what paragraph 84
No,
in
I'm not.
O'Donoghue,
No, I'm
the
not.
Strasbourg
No, I'm
court
not.
says?
No, I'm not, Milady.
Okay,
I'm not
it
denying.
is what it
Absolutely
says.
not denying. Absolutely.
Right.
I'm not taking you to O'Donoghue. I'm not saying that Mr. Justice Fordham got it wrong. I'm not saying...
Okay.
What I'm going to have to say later is the essence test needs to... I've anticipated a bit, but it's emerging as a kind of key issue, stands apart and drives outcomes in Article 12, and in a way that is sometimes unanticipated and look it in the face, is sometimes not as clearly seen in the European Court of Human Rights as it is in case law on essence in the European sector, in the European case law. And I'll be taking you, anticipating a little bit, and I'm sure my learned friend will want to discuss this in his response, to the President of the Court of Justice of the European Union's very helpful article on the meaning of essence. And he lays out what to me is a very attractive intellectual scheme, the attraction of which lies in it producing an outcome which I hope will find favour with my lady and my lords, but which is explicit. I'll take it to the point without myriads of cases, that the European Court of Human Rights has not always adopted as clear an analysis as I'm inviting my lady and my lords to take.
All right. Are we done with O'Donoghue?
We're done.
Right.
We're done with O'Donoghue.
Where next?
And I was going to take you, again in the same way, relying on the judgment of Mr. Justice Fordham,
Yes.
to the case of Hammer, which is in the authority bundle at page 296. I'm not going to take you to the details. I just observe that we had there a finding of an injury to the substance of the right, and it's mentioned by Mr Justice Fordham at paragraph 40 of his judgment. And F, may I go on? I mean, F in Switzerland, it's in the authorities bundle, pages 302 to 315. There is a summary at the bottom of page 36, and it's quoting paragraph 40 of F. I'm not going through the facts, my lords, my lady, but it's on the issue of principle. Again, we don't doubt the accuracy of the textual citation. Mr Justice Fordham says, 5 lines from the end of the page on paragraph 41, the prohibition affected the very essence of the right to marry and was disproportionate to the legitimate aim pursued. There we have those words sneaking in again with the hint of a composite approach. We say
Well, first of all, do you say that that's an inaccurate distillation of what's at paragraph 40 in F versus Switzerland?
no.
No.
What we say, milady, I think we have to say this, is we'd have preferred the word therefore
Therefore,
before disproportionate. We don't think, recalling my early submissions, we don't think you can have an attack on the essence of a right that is nevertheless rescued by being proportionate. We say that an attack on the essence of the right is the end of the matter. We say, when you ask the question, is the essence of a right affected? We get to that, and my lords and my ladies may have a view on whether we have established that on these facts, but leave that to one side for now. We say that as a matter of good jurisprudential analysis, weaving our way as intelligibly as we can through these cases, there is a test of essence, and we foresee no circumstance, putting all our cards on the table, where a right, the essence of a right, could be damaged, taken off, obliterated, defeated, and that nevertheless the people doing the attack on the essence survive unscathed because the attack on the essence can be established as proportionate.
I'm sorry, I don't want to delay your good progress, but as we're looking at these cases, would you mind if we just went back to the case of Hamer, which you
absolutely
mentioned a moment ago?
Yes.
In our authorities bundle, the part of it, we have it at 296.
Yes, thank you.
Where we see that it's the prisoners marrying
Yes, that's right.
case. So there's an opinion and it then goes to the Committee of Ministers. But the page that I wanted to ask you about was page 300, paragraph 72, where I think on an early reading of this one gets to the conclusive part. And in that paragraph, as I read it,
Which paragraph? Sorry.
72 on page,
72,
on page 300.
Yeah.
In that paragraph, the opinion seems to follow the traditional route that there is found to be an injury to the substance of the right to marry by not being allowed to marry in prison. But then, in a perfectly predictable way in the middle of that paragraph, the reasoning goes on to say that there's no general consideration of public interest that can justify such interference in the case of a prisoner. Isn't that authority really a quite conventional way of approaching it? I understand that you say that Article 12 enshrines an important, strong right and so forth, but we're concerned here with process and whether it's a two-stage process or, as you say, one stage. It doesn't seem to bear you out, does it?
It is my submission, and I take your point, that there are a variety of ways in which Article 12 is presented in the cases we discussed. And that is why I started with Bayer and spent a bit of time on the authority from within the jurisdiction, in which there is, we say, a rigorous analysis. We say that it is not appropriate to do what has been discussed there. In camera, I don't think it's quite as explicit as perhaps might be thought. I think it's a general looking around for reasons as to why the article is not infringed, and it could, although it's a very speedy reading by me, as being seen as wrapped into the question of essence. And so it's not impossible that when discussing the breach of the essence of a right, questions about what the essence is and whether the essence has been infringed in a given case involves considerations that could be repackaged and applicable elsewhere as part of a proportionality test.
Thank you.
It can't simply be that there is one question: does the measure impair the essence of the right to marry? If so, claimant wins, because there are national laws which clearly not only make it difficult, make it impossible to marry in certain circumstances. As you said, a 5-year-old can't marry. Nobody suggests that they should. So a law saying that the minimum age is 16 with parental consent, 18 without, subject to argument about parental consent for 16-year-olds, nobody suggests that there's anything wrong with a law preventing young children from marrying, but undoubtedly it not only impairs the essence of a right to marry, it prevents it altogether.
Yes.
So there must be some gloss on an apparently absolute right, whether it's public interest or proportionality or something like that.
Yes.
Mustn't there?
The idea of the essence of a right is not in the clouds that once it's identified, then sees off all underlying facts in a case and declares without regard to further discussion that there has been a breach. What it seeks to capture, and it's grown out of European, national European and European case law and transplanted into the European Convention, although I'll be frank with you, I've already said it with regard to the reference I made to the President of the Court of Justice of the European Union, not always with immense consistency. What is captured within the test of essence is not, as I say, something in the clouds. It's something which embraces within it the factual matrix that determines whether the essence has been affected in this case. And we get on a bit later, if I may, to fleshing out what is meant by the essence and giving examples of the essence. It doesn't exist in the clouds, repeating myself for the third time. It has a tangible location within a factual matrix. It does, therefore, embrace such common sense aspects that you, my lord, have identified in your question, but it does it in a way that is different from, this is our core point, and is different from the ordinary test of disproportionality. And if they were going to say proportionality, they say the disproportionality flows from the finding of essence being breached. And we say authority for that is to be found in the Bayer case, is to be found in the O'Donoghue case, and we say it's to be found in the way in which Mr Justice Fordham has deployed Article 12 in this, the first part of his judgment.
Right. Sorry to have interrupted your flow.
I mean, you're inviting me to acknowledge that the European Court case law is not always speaking with a clear and precise voice. If we see Goodwin, may I take you, my lords, to Goodwin?
Yes.
Which is in the authorities bundle 316 to 355. It's an example, quoting towards the end, noteworthy features for present purposes. And it's about 7 or 8, 9 lines up from the end of paragraph 42. And the sentence starts, noteworthy features for present purposes. Goodwin...
I'm sorry, I'm lost.
Oh, I'm sorry, my lady.
No, which page is that in the bundle? We were at 316.
Yes, I'm now back, I'm sorry, with Mr Justice Fordham's judgment.
Thank you, I'm sorry.
I didn't make that clear.
Fordham, paragraph 42.
I'm back.
Fordham at 42, I'm so sorry, yes,
not
of
at all.
course.
I don't need yet to deploy my alibi of having just begun to prepare this an hour before the hearing, but I reserve the right to head in that direction.
The fault is mine. 42, yes.
So far.
And so we're looking at about 3, 6, 9 lines from the end of the long paragraph 42. And we see, like F in Switzerland, Goodwin is an example of a national measure with an outdated social rationale. The court concludes that the applicant's right to marry has been infringed without recording any finding that there was a present intention to marry. And we say that that reminds us both that if there is an outdated social rationale, it does not assist in defending against an assertion that the essence of a right has been attacked. And we also say that a desire to marry will be enough here. An intent to marry, obviously, but a desire to marry as well, because our clients cannot plausibly, because of what we say the inhibiting effect of regulation C9 is, cannot plausibly say that they intend to marry, because the inhibitions financially are too great, but they certainly desire to marry.
I don't think that's quite clear from the evidence that was before the court below that all of your clients necessarily desire to marry. They at least one of them, desires to have the opportunity if that arose. I think is the way I would put it.
Yes, I stand correct. And of course, one of our clients did marry.
Yeah,
Did
absolutely.
Yeah. Now, I'm moving to the end of my first of my 3 points, central. And if we take you back to a summary of what we believe Mr. Justice Fordham laid out, it's in our skeleton argument. It's at paragraph 12. And what we did in our skeleton argument was try to summarize. My learned friend will no doubt take a view. This is us, not Mr. Justice Fordham. It's our distillation of what we say Mr. Fordham was at. In this, we say the effective and correct piece of the case. The very essence, I mean, it's in front of you, my lords, my lady. Yes. I'm on our skeleton at paragraph 12.
Yes.
I'm not sure I need to read it, do I? Would you like me to read it? Or will we just look
No,
at it?
don't read it out. We'll just
Absorb.
glance through it again.
Yeah. We, being lured back into composite tests, we do say arbitrary and disproportionate, even allowing for the margin of appreciation. That's Roman numeral 6. But we say, I'm repeating because I think we need to say this, we can envisage no circumstance in which an impairment of the essence of a right can be rescued by being shown to be proportionate or non-arbitrary. But arbitrariness, and in some circumstances, without being driven by the case law on Article 14, etc., questions of proportionality can feed in. This is back to the point my Lord asked about essence earlier, can feed into assessments of whether the essence is breached, is attacked by this or that decision or regulation.
I just want to flag up my own difficulties with that proposition, because it seems to me that you're not comparing like to like with like. That in considering the essence, one's considering the right and the impact of the measure on the right. But in considering proportionality, one's considering the competition from other rights and interests.
Yes.
And so it seems to me that since conflation is in the air, this may be an unhelpful conflation of the two, because it blurs the distinction between the two. But one might, and this is not your submission, but one might have a very grave interference with the right to marry, which, I'm sure it will be said, could be justified by an even graver interference with somebody else's rights. And those are two different rights.
Yes.
It's not that the second one is relevant to the essence of the first. At the moment, I mean, I don't think at the moment we're dealing with process here. It's not to do with the merits of your client's
Correct.
claims. It's to do with process. And at the moment, I have to just record that I'm stuck on
Yes.
the apples and pears
Yes.
nature of this
Yes.
argument.
Let me, if I may, take a little moment. This is how we see it operate. Proportionality is now explicit but introduced by case law in the operation of these other, as it were, fruit. And it has a double application in other places. So, for example, an Article 8 versus Article 10 case, something we're very familiar with. So how do you work out where the rights fit versus each other? And as we know, Supreme Court cases now show, you need to work out what these rights are mainly about, and you have a proportionality balancing about the importance of two rights. And you have, within each right, you've got this other proportionality balancing. And the essential feature of those cases is balancing either right versus right, or it's right versus legitimate public interest, national security, the rights of others, etc., etc. And that takes you on the fourth limb of the ordinary test of proportionality to check where the balance of the public interest lies. That's the, as it were, without being rude about it, bog standard approach to proportionality in the case law before the convention. Article 12 does not play those games. You don't, sorry to be rude about it, but nobody balances the right to marry against a right to this, that, or the other. There are no conundrums related to when the right to marry should give way to this or that other right, apropos, for example, Article 8 as against Article 10. That doesn't happen. And also, and this is central to our argument, what doesn't happen is, using my almost abusive term again, the bog standard proportionality test is not applied. You don't tot up the bits of public interest that lie in denying a person's marriage against the importance of the marriage to him or her or they. It's not that. So when Lord Bingham in Bay, if it was Lord Bingham, I think it was, talks about it being a strong right. And when they talk about it being a fundamental right, they're not quite saying it's like the right not to be tortured. I'm not going there. I'm not going there. For one, it's a positive right, so it involves the state and an obligation to act. But they're not far off it. They're sort of saying, look, this is a very different sort of thing. But they are, when they say this is a very different sort of thing, they are acknowledging my Lord's earlier point that it doesn't mean that you can just endlessly claim a right to marry in any circumstance, no matter how absurd. It involves the application of a test which asks about essentiality. And essentiality may embrace aspects of, and we'll get to, when we try and attempt to work out what it means, we get to this. It may embrace aspects of the factual circumstances in a case, which aspects would be relevant were we also discussing Article 8 or Article 14. But they are in their own space marked Article 12, essence. And we, reverting to where I was and acknowledging it, we prefer the European Court of Human Rights to speak with the precision of the President of the Court of Justice of the European Union in the article to which I will take you at the end of my submission. And we will note, and I'll take you to the term exactly, the President's remark that the European Court of Human Rights does not always unambiguously follow the route that I'm suggesting, but it does to some extent. Its leading cases do. Its distillation of the Bai case and the O'Donoghue case in the hands of Mr Justice Fordham do. It is true there are sentences where either preferred and therefore disproportionate. I will take that, as it were, hit, but we will be on a very difficult wicket if any of us try to secure a wholly consistent European Court of Human Rights case law which fits together intellectually in a way that's both consistent and pleasing. So we say I nearly said that we've got the essence of the test of essence, and that is particularly one which does not deny the factual matrix around you, but looks at it in a different way, resists the balancing of rights, to go back to where my Lord was a moment ago, the pears and the apples, and resists categorizing it as just another right to which the test of proportionality applies. It is not.
Yes, my only qualification to all that is, it seems to me there must be a value judgment somewhere to be made. There is no, the right to marry is a very strong right, but it's not an absolute right, because it's prohibited in the case of young children, prohibition of bigamy, prohibition of incest, prohibition on sham marriages to evade immigration regulations, say, except at the fringes of the last one, scarcely anyone would quarrel with any of these. But that's because the value judgment of all decent people, including members of the Strasbourg court, is that, of course, those the prohibition is absolute. Boy, does it impair the essence of the right to marry. It prohibits marriage altogether, but it's justified. So there's a value judgment there. Then you go into the slightly less obvious cases, say Goodwin, in which the Strasbourg court reversed several of its previous decisions in holding that the applicant was a transsexual who, under the English law as it stood before the Gender Recognition Act, the rule was once a man, always a man, once a woman, always a woman. Therefore, the applicant remained a man in law, even though he had transitioned to being a woman. Therefore, he couldn't lawfully marry a man on the law as it stood then. So there was a total impairment, in effect, of his right to marry. Strasbourg Court said, we used to say this was within the margin of appreciation of the UK, but no longer. We take a different view. There must be a value judgment somewhere, whether you call it proportionality or prohibition against what's arbitrary, and the value, the nature of the value judgment will depend on how total a barrier which the law poses to marriage is, but it can't simply be, does this impair the essence? If so, the claimant wins, can it?
And let me approach it indirectly, but answering. There are a number of rights which appear on their face absolute. Article 3, prohibition on torture and human degrading treatment. And so a lot of the action there centres on what these words mean, because there's no margin of appreciation to speak of there, and certainly no test of proportionality where you can say the chap knew an awful lot about the explosives, so we had to torture him. So that one's on one side. But on the other side is an article like the prohibition on discrimination, which is 14, which you will know. If you look at that, it's on its face absolute. There are controls because it has to be in the context of certain statuses, and you will be very familiar with the rigorous analytical jurisprudence that's grown up around it. But my point is this, that the court have chosen to moderate the impact of Article 14 through the language, quite explicitly, of proportionality. So they've taken your point and said this can't be just absolute. So let's test it and let's use the language of proportionality. When the courts deduced a right of access to a court in Golder, wandering back off theme perhaps, but when they deduced it under Article 6, there was the obvious question, well, does everybody have a right to a court? Does that mean I can just wander in because my teeth aren't as clean as I'd have liked? No. There's a test of proportionality, which is balancing the public interest in access with the various public interests in restricting access and so on. So you're allowed to have vexatious litigant lists and so on. So choices are made to control, and the control is often, but not always, proportionality. Choices are made sometimes to have no control, Article 3. In our case, there's no term essence in Article 12, and the regulation is, I say that now petrified that there is the term essence in Article 12, but I can rely on my learned friend to make the point very gently after the break. There's no, so what they have done is they've said, well, we can't have what my lord is talking about, we can't have the whole world just getting married just for the hell of it. So we have a restriction, which is marriageable age. So we have something in it already. And so national laws are in a way to facilitate. They're not a restriction, they're facilitative of it. And we've decided, the court in its more, in what we would say is the composite clarity of its position on Article 12, has decided the test is essence. And so that test is supposed to weed out, if I may say so, is supposed to weed out opportunistic and sort of, as it were, far-fetched reliance.
Can I just ask
Yes.
this? I know you'll want to move on, but in Bayi, paragraph 1, Lord Bingham says the agreed issue is whether the scheme involves a disproportionate interference with Article 12. So I think you may have not just a conceptual hurdle to clear in saying that it's all wrapped up in essence, but as it were, a precedential aspect in that the House of Lords in 2008 were perfectly happy to approach it through the lens of proportionality.
Yes. We I mean, without remembering it, it's the agreed positions in that one. And I suppose
Well, I can
No, it-
cite back to you other places during the judgments in which proportionality is referred to. But,
Yeah.
I mean, in a sense, I didn't approach it in the way that you're suggesting it should be approached. But there we are.
yeah, I take. I am seeking to distill a position which borrows from and draws strength from the plurality of the case law understanding of Article 12. And the position is, to some extent, at bottom, an intellectual one, that you can't have a test of essence and a test of proportionality if the essence is breached, because it makes no sense. Which is why, going back earlier, I was rather sad not to see the word therefore in the sentence that grouped essence with arbitrary and disproportionate. Now, you may say, to some extent, this is an ambitious argument. It may be over-intellectualizing, but we need to make sense of Article 12 in order, if I may, using this as a sort of hook to proceed, if we're not going to fall into what we most respectfully say is the error into which Mr Justice Fordham fell by moving on, as it were, to embrace what we say are different tests.
All right. Now, I make this criticism of myself as well. I asked you a rather long question when you were about to move on to something else. You said that part one of your three-stage journey was where you were a fan of Mr Justice Fordham's judgment. Are you now going to get to stage two where you're not such a fan?
I fear so.
Right. Well, should we go on to that if we've done stage one?
You delayed the swoop on Mr Justice Fordham, but it's now the second and in some ways central observation. Why we're here? And we're here, you will recall, because Mr Justice Fordham wanted us to have a look at it. He gave us leave to appeal. Now, I'm not implying that he's, as it were, on our side, metaphorically tugging at my ropes. But we're here with leave from the High Court judge. And what we're saying is that he moved, we're looking at Mr Justice Fordham's judgment. He moved from this exercise on Article 12, not to apply it, but to have a look at other aspects of the arguments rooted in the then live arguments based on Articles 8 and 14, grouped with 8 and Article 1 of the first protocol. And so we see what we say is an error of law gradually making itself manifest. And this is how we say we see it. We see justification driving the analysis. And we see it starting at paragraph 68. It's in what Mr Justice Fordham calls Part 8, Analysis, on Justification. I'm on paragraph 68, my lady, of Mr Justice Fordham's judgment.
Yes.
I'm in the right place this time.
I didn't mean to be implicitly critical, I'm sorry. And what we see here is a couple of remarks. My learned friend will spot if I've not misrepresent, far too strong a term, but if I haven't covered it as completely as we should, and you'll pull my robe. In the next part of the judgment, I will address, this is the very opening part of paragraph 68, head on the argument about whether the Home Secretary can demonstrate an objective justification viewed against the standards of justification which apply in the context of the Convention rights relied on. Head on. And a bit further down, and this is taking us to the core point that my lady identified earlier, and I don't think I can avoid it, which is that I recognise, as we submitted, and Mr Bryan accepted, that Article 12 breach can be said to involve a composite question. I think, my lord, my lady, that a composite question makes sense and was intended by my learned friend in the following way. That is to say essence does not exist as an idea in a vacuum, insulated from all facts. Essence involves scrutiny of the factual matrix, and it's a scrutiny driven by the question whether the regulation under scrutiny is one which impairs the essence of that right. And that is a question, we'll get to it when we look at what essence means, as it were, which is composite to the following, in the following way. It embraces aspects to it which can easily be aspects, I'm repeating what I said earlier, that are also deployable in the context of the, to use another term I used, bog standard tests of proportionality. So that's what we mean today by composite. We say, and it's a version of the answer to my lord earlier, we say essence does not exist in the clouds. Essence has dimensions to it which are part and parcel of an assessment of what is entailed in a right. And that can involve issues of let's call it issues of social interest and issues of possibly even non-arbitrariness, issues that might well pop up in different contexts under the test of proportionality. But we say the distillation of the cases under Article 12 takes us to an understanding of the Article 12 test as being separate. And we say that that composite nature of the factors that underpin the question of whether a right is breached in its essential, in its essence, is a composite question, but not one which embraces within it the bog standard test of proportionality, because it cannot. Because there is no point to the test of essence if that were the case. What you would have is you'd have the ordinary case law, you'd have had on Article 12, you'd have had exactly what you have with Article 14. You'd have said, look, this looks like an absolute right. Well, that's ridiculous. So let's have a test of proportionality. You'd have had what you had when they developed the right of access to the court. That's ridiculous. Let's have a proportionality test. You'd have had that. We don't have that.
So you say it goes to the essence, and there may be factors which would be in the brand hub in relation to proportionality, real, as you would call it, but you can use those factors, and they may come out of that general brand hub and be used in this composite question, which is, has the essence been undermined? And so when you're doing that exercise, you've nevertheless got to look at, you're saying, all the factual matrix, and therefore, I mean, we've been over this, there is discussion of the use of whether it's a disproportionate, etc. But you're looking at the effect on the right in its proper context.
Correct.
And you say that gets one to a different place.
Correct.
But, and this is jumping right ahead, and you'll come to this, no doubt, Professor, but isn't that really what the judge did when you look at paragraph 93, because you'll come to those paragraphs later, and I'm not trying to make you jump forwards in your submissions, but he looks at particular factors which were factors in the proportionality brand hub, and he applies them specifically in relation to the essence of the right to marry and whether the C9 is addressing that essence and whether that essence is affected. So when it comes to it, when we've been through the jurisprudence and the academic analysis, we've still got to look at whether what he did was wrong.
Yes.
And,
yes.
And therefore you come up against paragraph 93.
We do come up against it. But
Sorry to interrupt. This is just a suggestion, invite my colleagues to say if they think this is the wrong way of thinking about it. But the judge, we've got to paragraph 68.
Yes.
The judge mentions, and it's right that we should mention at this stage, that the inhibition which the regulation involves has serious implications for private life, happiness and companionship. Then at 69 he states his conclusion that he's unable to accept that regulation C9 lacks objective justification. I appreciate you say that philosophically you're not quite happy with that as the question, but let's assume for the moment that that is the question. He then goes on to give 12 reasons why he's come to that conclusion. And I would find it helpful if you would say, of the 12 reasons, I don't mean how many you accept and how many you don't, but if you just go through them and say 1, that's all right, 2, that's all right, 3 is wrong, and so on.
Yes.
Rather than jump to the conclusion.
Should we give it a go? Should we give it a go? I think, my lord, I'm very happy to be guided because I think this probably is a core, if I may say so, it's a core issue. You know?
Yes.
I'll preface it by, if I may, mentioning Milady's point, because it allows me to say this, and we'll get to 90, whatever it is, but at that stage we think the game's up for us because Article 12 has been subsumed within the preceding language of justification of proportionality. We say this: the whole point of this essence thing, and the whole point of saying it's a strong right and it's a fundamental right, the whole point of it not having exceptions built into the body of the article is rooted in the historical understanding of how awful it is not to be allowed to marry. And we'll get on to some of the claimants later, and there are rather sad stories scattered around the country on this. But is to put the state on its guard. So the state is not particularly being put on its guard with the test of proportionality in the operation of Article 14, for example. It's a balancing, and so what we're asking for, I think, listening to you all carefully and wondering about what essence means, is we're asking for a slight elevation of the burden of justification. I mean, that may be putting it too lightly. My learned friend may swoop on it. But we are looking for the state to be on its guard. And here's, I'm loath to draw in anything on Article 14, and I'm doing this extremely carefully. I'm doing what I'm going to do now very carefully. There is a general recognition in Article 14 case law, which is that there's a difference between suspect categories and non-suspect categories. It was before the High Court, and it's no longer before us. But what it captures is a difference in a methodological approach where it's a certain kind of discriminatory treatment.
Can you remind me, is Article 12 in a suspect category?
No, married, that's it. I don't know, actually.
No.
I'm not sure it is, but it would belong as status, I think, wouldn't it?
Yes. All right.
Yes. Marital status is certainly a status. Article 14.
I don't think it's explicitly reference functioning heroically on my behalf.
Well, as you rightly said, we're no longer concerned with Article 14.
We're no longer concerned. Maybe we don't hugely need. We're not concerned with it. But what we are concerned with, and why I've tentatively raised it, is we're concerned with the idea that the state is put on its guard. And we say that essence puts the state on its guard. It's a reminder that Article 12 is different than the others, and that you need to be jolly clear that you are justified, using the language that I'm going to with my Lord in a moment. You're jolly clear that it's worth, as it were, doing, and that affects whether the essence is transgressed. So that'd be my. I think it's what I think our side need to say.
Yeah. I realise that you have
12
to go, but I wonder whether we've not circled around and landed back where you were when you were addressing the judge below. We have your submissions to the to the judge below at page 125 of the core bundle at paragraph 68. And I don't. If you, I can read them to you, or you can find them. But I wonder whether, having taken flight in relation to this important issue, you haven't, in a sense, arrived back where you started, which is in paragraph 68, because in a sense that captures much of what you say, but you're obviously going to be in some difficulty in trying to persuade us of an argument that's different from the one that you addressed to the judge.
Yes.
And that appears to be where you started off
Yes.
with this.
Yes.
So are you content with that?
I think I have to say, if I look again at this paragraph, that Article 12 is the very essence, and I would modestly say that if the very essence is impaired, it is by definition arbitrary and or disproportionate. And I would say that the very essence right is governed by a number of factors, which include these, and that its feature is to put the state on its guard, a point I just made. And it's not a simple move from one to the other.
All right. Well, whichever it is, whether it's whether the test is it arbitrary and or disproportionate, and therefore impairs the very essence, or whether it impairs the very essence and it's therefore arbitrary and disproportionate, whichever it is, I would be grateful for your assistance on at least the great majority of Mr Justice Fordham's 12 points. I say the great majority because I think the death in line of duty issue was only Article 14. You're not pursuing that. That's rather freestanding. But but I would like to know what you say about the other points.
So I'll give it a go. I think I'm starting at paragraph 70.
Yes.
Is that correct? And I'm imagining that I'm making submissions, but written submissions, to say that the test that you've deployed is one of essence in which arbitrariness and disproportionality form a part. And I'm saying that you take your analysis of justification from your understanding of the importance, the fundamental nature of the right, and you are not eliding it with others, articles this or article that, and you are looking at it as an Article 12 issue, fully on guard. Those are my preparatory remarks. So you say, my lord, getting into it, that it's not great to have an objective justification which has an historic social rationale, but none today. We say, well, actually, the right to marry is jolly important. And so we're not going to let you off the hook on that. And if you can say that the essence of the right to marry was not affected in 1982 or 1976 or whenever it is, but you admit that this is no longer defensible, we say, well, that does matter with Article 12. This is not about pensions and welfare. We're saying that. So that's the first, if I may.
Yes.
And I think we're saying that rather robustly. We're saying Article 12 leads you in different, less benign directions so far as the state's justification is concerned. Secondly, we say we are less worried by the linkages, the prospectivity point, the point about people, which is a very important part of this judgment on Article 14. We're saying pension scheme benefits, yes, the people need to be in it to benefit from it. This looks like, if you remember what this one means, kind of people able to benefit from a scheme not having paid in a way that takes into account this cost. We say, well, that may apply with Article 14 non-suspect categories. We say we'll be pretty careful before we'll allow a bookkeeping device.
But yes or no, Professor, and also why is that not part of the context which you said one has to look at when one's looking at essence.
What it's part of the context, and
It is part of the context.
I'm saying we're balancing it against the attack on the marriage of the claimants, and so we are doing some degree of comparison here, and we're being guided into applying a test of essence which embraces elements of justification. I'm saying that this is not a deal breaker so far as the right to marry's essence is concerned. This does not mean that the right to marry is not damaged in its essence. We're saying that it's a part of a context, but not an important one. And my lord invited me to critique them.
Yeah.
And I'm saying, on my approach to our approach to Article 12, the composite question as I presented it earlier, the essence test embracing these wider issues of justification and proportionality, I'm saying that these are not wins for the other side. These are factors, but they are not critical. And I'm saying that. I'm saying the right to marry is a strong right, an important right, and I've been rude about it, but a bookkeeping device should not deprive people of the prospect of a happy marriage.
Okay.
The third, I think this is one that we don't need to talk about, is it? I suppose going down, I think this one is an example of where there's a test of disproportionality for the Home Secretary not to have amended. I'm not sure this one, does this one figure apply to us?
Well, I think it does, in the sense it's back to, are you accepting that this is context, in the sense that the schemes changed in 2006 and thereafter, and that the schemes closed to new membership and thereafter to accrual of benefits and all those things.
Yeah,
So it's another wrap around.
We say, I mean, this is not something which my clients would have said and don't say. But if this scheme had been closed down, and if everybody had been forced into the new scheme, or people wouldn't be there, this wouldn't have applied. But they kept the scheme. And we say, insofar as I understand this one from a quick glance, what you're saying, we say that our claimants should not be penalised for for their deceased partner not having joined a scheme that was available, which very few people took up in a way that now comes back, as it were, to damage them, when the original scheme was retained. So do you see, I'm sort of saying, the gutsy thing would be to say, well, that's the end of that scheme. You get into this one or get out. But that didn't happen. So the original scheme continued, and we say, at face value, we say that shouldn't be penalising those who desire to marry who were previously married to deceased members of the force.
But you do accept that it's part of context.
Yeah, you see, this is where I think it would be eccentric of me to deny that it's part of context.
And it's also part of context, therefore, Professor, that one has to look also at the bundle of rights that one has in the old scheme and the bundle of rights one has in the new scheme.
Yes.
And look at those rather than narrowly only to look at this particular benefit.
I think that's right. And I think that, at the risk of repetition, I'm saying these could be, and I think to be clearer about the fourth one coming up, these could be gentle justifications where it's a matter of a non-suspect category searching for justification in a field of financial benefits under the discrimination provision, but are not effective in the same way where it's entrenching upon a fundamental right, the right to marry. Back to there being factors, I couldn't deny that, it'd be eccentric to do it. We haven't come close to even understanding what essence means, and we should give it a go, I think, at some later point, which would be my third point. But these are factors, but lighter factors. Lighter factors.
Okay.
This is a strong right for a reason. It's a strong right. And then we take, I think, if I may continue, Maro, with your challenge on the numbers. The fourth, Harvey we say, I think we have it in my, I may,
Well, can we start with the first,
Yeah.
first sentence of 73?
Yes.
The judge says there's a policy coherence and an integrity in holding to pension scheme rules which have been designed and costed and to which active scheme members have contributed.
yes,
Now, that's right, isn't it?
yes, yes. We say there's a difference, if I may, between
Yes.
the right to marry and not being able to marry, and the right to obtain a pension or a benefit which was available to persons who were married, but is not available to a cohabitee. We
Sorry, I'm
say,
slightly lost.
excuse
Yeah.
me, sorry,
No, I just want you to clarify that. I'm slightly lost.
I'll unpick that.
Yeah.
But it's core to our argument, so I think
Yeah.
it's worth spending a second on it. We said in our skeleton, no need to go through it because I'll read it to you, and it's directly germane to this. If we were to suppose that Regulation C9 only applied to cohabitees, but did not apply where the surviving pension benefit holder remarried, then it would be like an Article 14 case. So we say these cases where there is no marriage involved, but the cohabitees or persons who are not married are seeking the benefits that are available to married persons, we say that would be nothing to do with the convention. There'd be no Article 12 point. And it's therefore not a surprise that there are no Article 12 points on them. So, I don't want to go. We say about this paragraph 73, we say, and I think we push it this far, the deal breaker, so far as the fourth justification is, derived from Article 12, but not derived from Article 1 of the First Protocol or Article 14, is that we are talking about people who are not able to marry. We're not talking about people who are living together and want the benefits of a married person, and we are talking about marriage because it's what's in the convention, very explicitly, and it's marriage, it's not anything else. And so we say that's, as it were, a very important additional point available to the Article 12 argument, which has collapsed in the treatment of Article 12 in the context of justification.
It occurs to me that there may be a causation issue, Professor Gertie. In the case of a couple who have not moved in together, but who have begun a relationship, if they move in together, no question of marriage at that stage, but the widow or widower of a scheme member immediately loses the pension under
Yes.
Regulation
Yes.
C9. Now, many would say that's outdated and
Yes.
reprehensible and so on, but it's not a breach of Article 12
Correct.
because it's got nothing to do with.
Correct.
And if that couple then go on to marry, that's fine, but they are no worse off than they were when they were cohabiting. It's only a widow or widower who goes straight from living an independent life to, as it were, attending at the register office or church or whatever it is, and only then moves in. It's only those cases which are affected by Article 12, isn't it?
Yes. Article 12 affects people who desire to marry, who are unable to do so because the penalties in the way of marriage, whatever we call them, foregone pension benefits, taxes, charges, are such as to render, we say, the essence of the right, so far as they are concerned, impaired. We say in the test, these various criteria we're at, fourth or fifth, are deployed, but they're deployed against a backstory of the importance of the right to marry. We say Of course, if a client showed up who was cohabiting and had no intention of marriage, for whatever reason, we needn't go into it, and they thought their rights were being infringed and they were very cross, and we all thought it was very unjust, we'd go down the Article 1, Protocol 1, Article 14 route. We'd go down the Article 8, Article 14 route, and we would make some of the noise we made in the High Court about the inappropriateness of that, and the ordinary, using my term again, bog standard test of proportionality would apply, and they would face an uphill task. And we say, my lord, going to your point, if they then fancied getting married, and they rather thought, wouldn't it be nice to reapply to get the pension back, or even if they, and it would be theoretical, but if they opportunistically married in order to secure the retention of the pension by deploying our Article 12 point here, we'd say that would fit within the context of a sham marriage. If there were a whole lot of emails saying, I hate marriage, I've never wanted to marry, marriage is awful, but let's do it because then we win in the Court of Appeal on Article 12, we'd say, well, we're not representing those because it's part of the earlier case law that it's not just marriage, it has to be a genuine marriage. So we say, in answer to this one, we say, everybody goes on about the convention being a living instrument. Well, here it's not. Here it's not. We say we are sort of in a world where marriage matters. And marriage has not been extended in this way. Article 8 has done quite a lot of the work, irrelevant to us here. And Article 12 stays where it was in the 1950s. So we have got an old school right to marry. And we say that the policy elements that are identified in this fourth point are policy elements that absolutely would drive decisions which are engaging other articles. Cases like Brewster, Harvey, Eccles, unsurprisingly deploying a proportionality test which leads to justification, are all cases in which the issue is not about the right to marry. And in Lenin, the right to marry wasn't argued. We don't have authority. Now, my learned friend there may be other authorities that I've not gone to, but we say that the policy coherence point applies where a strong and fundamental right is not engaged. It is, of course, part of what I've re-described as our composite question. It's part of it, but it's not a driver in the way that it is where nobody is interested in whether the essence of the right has been affected. So as this argument is developing, I'm finding myself thinking of essence as a kind of almost like a suspect category type thing, where we're saying you need to be very careful to justify this much more completely, or we will find the essence of the right has been infringed. So these are, on my analysis, important background aspects, and therefore to that extent composite, of the fundamental question: has the essence of this right been impaired so far as these clients are concerned?
Okay. Let's press on with Mr Justice Fordham's 12 points.
We have
unless my
yeah.
lord and my lady think otherwise. Number 5 is a bit esoteric, but number 6 is perhaps important, and number 7 is certainly important. So should we go on to number 6?
I say, as regards 6th, and I think it's part of what I was saying as regards 4. I think skip 5. We go sort of 3, 6, middle. I'll try middle. Quoting Brewster, the point being conscious and contemporaneous policy decision making, and this being an important factor in finding justification. Conscious, I'm quoting a sentence that starts, conscious and contemporaneous policy decision making on the relevant issue is significant for the reasons explained by the Supreme Court in Brewster, a case in which the justification put forward was ex post facto. I'm saying that Brewster and many cases of that type are not cases engaging the right to marry, and to determine that, as he has Harvey, an important case in the area, that it has a crossover effect into Article 12 is to miss the importance of Article 12 and not to take it into account. These are all cases derived from an analysis of justification under Article 14. All of them. We say at the end of paragraph 75, if I take it down to 4 lines from the end, we say the claimants do not submit that Harvey, Carter, or Eccles are wrongly decided. No, we didn't. We didn't submit that. We didn't have to. If we'd had clients like Harvey, Carter, or Eccles, we'd have had to have done. But we are on 12, so we don't have to. And we'd say, therefore, the 6th is background, but not decisive. And we say those that we've acknowledged are background are cumulatively not decisive in my redesigned composite question, because they do not outweigh the strength of the right, the vigilance required to protect the right against the destruction of its essence in individual cases in a way that protects the schemes from challenge. And we say, and this is a very good example of the more general point, Article 12 is special in that way.
All right. Now, paragraph 76, enormously long, deals with what seems to me, speaking for myself, an important point.
Yes.
In 2006, a new scheme was introduced. The old scheme was closed to new members, and the old members, if I can so describe them, were given the choice to move to the new scheme, which was worse in almost every respect, except that it provided survivor benefits which would not cease on cohabitation or remarriage. And I think Mr. O'Brien is going to say that to accept the claimant's argument would be to allow them to have their cake and eat it, in the terminology of the late Prime Minister.
My answer is that they could have ended the scheme. They didn't. Choice was given, wasn't mandated to change. And if the first scheme breached human rights, which we argue it does, albeit specifically focusing on Article 12, then so be it. That it's not a sufficient reply to say of the claimant's partners, now deceased, that they should have, and in not having joined the new scheme, somehow or other, the essence of the right to marry, that is, everything else being considered breached, is saved by the fact that they did not do so. We say, once again, and this is very much in play with my second of my 3 points, which we're on still, where Mr. Justice Fordham, as it were, we think took a wrong turning. We say that these are plausibly central aspects of an ordinary test of justification inviting the ordinary test of proportionality in the context of financial benefits and so on and so forth. But that it falls away where it is a strong right like that of Article 12, we say. So we don't make the point that almost nobody did change. I haven't got the facts. I'm not going to claim that. I know we had them in the High Court, didn't we? The number of people who changed over, and so we're not saying that here. We're not saying it's nobody thinks they're ever going to die until they're dead, and even then they don't know it. We're not saying that. We're not saying they jolly well should have spent time as a couple perusing the special print in the booklet that's sent around. We're not saying any of that. We're not saying any of that. They chose to remain in a continuing, functioning scheme, and they have found that the scheme breaches their human rights under Article 12, and this is not a deal breaker against that. That's what we say. That's what we say.
Right.
We see the power of that argument in the context of other tests, which is why, my lord, if I may, we've dropped other grounds of appeal, because we see it. Are we on 8?
Yes.
Significant economic implications of disapplying PPS. I'm in danger, I don't think it matters, but of repeating a core point. Absolutely central, where it's not a strong right that's entailed, where there's no suspect category, to borrow language from an article upon which we're not relying, where there's an inevitable proportionality balance in the ordinary way between the rights of the individuals to avoid living a grim life and the vast call on the exchequer that will be derived. It is speculated by the litigants following the path of the litigants here, and or changes to the rules in anticipation of such litigation, or simply as a result of good governance. We say that this is an example of a strong right, and the economic implications are there. We look them in the face. We have no other clients. We haven't got an array of people beating down the doors. We have no intervener from any other scheme seeking a win here to move elsewhere. We are only interested in our 3 claimants. We have one who has married and would like the money that is represented in the foregone pension since his marriage, and we have 2 that would like to be able to marry without financial penalty. We're not arguing, as we did extensively and rightly before Mr Justice Fordham, about foregone monies and how much you cost by getting it and so on. We're saying we have 3 claimants, and we're looking for the chance for 2 of them to marry, and we're wondering about the costs entailed in that, because they just carry on having the pension that they have at the moment. It looks neutral to us, though I'm not mathematically numerate in the field of pensions, and I'll be told, I'm sure, that it isn't neutral, but they're being paid a pension now, 2 of them, and they will continue to be paid a pension and lead fairly miserable lives, on which more at the conclusion, but not much more at the conclusion. And the other wants to be able to return to the position he had before his marriage. Not a lot involved with our lot. I appreciate my lord and my lady have to have in mind a wider picture. I in some ways don't. I've got 3 people.
In relation to Mr Sneller, who is married, would this, if it were considered to be contrary to Article 12 in relation to marriage, help him directly, because before he was married, he was cohabiting. He lost the pension because of the cohabitation.
Yes.
I just want to get precisely what you said about
Yes, it's a good point, and I have to take instructions, because I can't remember when he cohabited. Did he cohabit?
He did cohabit, and then quite rightly informed the pension authorities and had the pension withdrawn, as I understand, from the evidence. And then after that withdrawal, he nevertheless married.
It's a very good point. I'm answering.
And you're getting instructions now.
Yeah.
I'm very slow to rise usually, but it does strike me that this might help everybody, because one of the first things I was going to say, this appeal has obviously developed, and Article 12 is now the only thing in dispute. But what isn't yet clear is what the impact in terms of the remedy that is sought is, because Regulation C9 subparagraph 3 doesn't only deal with marriage and remarriage. And as I see it, it can now only possibly be that wherever the words marriage and remarriage arise, you cross them out. That's as it seems, and if that's clarified, then I think that's important that the court knows that that is the focus. I hope that's clear, and I thought better to rise while instructions are being taken.
Exactly. So if that is the case, does that mean that therefore Mr Sneller's pension would be reinstated because he is married and that should not be a barrier? Or does it mean that he lost it at an earlier stage in relation to another clause which would remain in C9? That's what
I'm looking across my learned friend, because this is the way I understand it. That whether he cohabited doesn't seem to me to matter very much, because if he loses the pension for cohabiting, which I don't think he did.
I think that was the evidence.
Was it the evidence?
That's the evidence as I recall it.
He cannot get the money back. On our analysis, marriage is what we care about. And
But he'd already lost. My point is, and I'm just asking, I'd like it, the conundrum resolved for me, is that he lost the pension as a result of cohabiting. It was already lost before he married. If
Yeah.
one strikes out marriage from C9, does that mean that he gets his pension back? Not clear.
I'll have a go at it.
And I think that's something perhaps you'll come back to.
I might come back to it in reply. We'll see how it goes.
I'm going from the page 49 of the bundle, just before Mr Justice Fordham's judgment. There's a sort of chronology, but it also gives some facts about Mrs Green, Mrs Jennings and Mr Sneller, which I hoped and thought were agreed. But
yeah, they are agreed. I'm sorry. He was cohabiting and then married, and I apologise. But can I don't want to anticipate, but perhaps if just to say quickly, and this may be over logical on my part, he can't get money back for an infringement of a right to marry during a period when he was cohabiting, unless he can establish something about how he had an intention or desire to marry. It's a sequential matter that would be complicated, I think. The simpler one is to say that from the moment of his marriage, the rationale for the deprivation of his pension was that he was married. And I can't now recall how we've calculated it, but in a way it would seem to make sense to say that's the starting point. But
you're being passed a note.
But in any event, I'm sorry to have delayed you.
Yeah, I mean, I think it might even be for another day if we're found in Pharaoh. But I'm instructed that they moved in together because they were always going to get married, and he was sort of in the case. Then he just got engaged, and we all said, marvelous. And I'm not sure if Mr. Steller's in the court, and then he got married and so on.
Yeah. Thank you.
Good.
Thank you. We're on 9th.
We are,
my lord. We say it is, I suppose. It's in the nature of a penalty on marriage. We say marriage or cohabitation is an important distinction. We used to have to say both, and we now say marriage only. And we say there's a difference, and we're relying again on our idea of the strong right, and we're saying there's an exactly perfect example of how it matters to distinguish Article 12 from the others. And it being a strong right, very important, fundamental, and so on, you can't just say it's not a penalty. We say it's a large penalty. That's 9, my lord.
yes. 10 has gone.
10 is the death in the line of duty, isn't it? That was our Article 14 point, which we've gone.
Yes.
11, we see what he says 11thly, paragraph 80, part way down. The intrusion necessitated by that inquiry is part and parcel of regulation, C9, and part and parcel of the evaluation of justification. We say marriage is a more public act. We say that you're not going to be spying through the window to see whether they're married. You're going to consult the records. We acknowledge that if you're going to have this rule on cohabitation, there has to be some mechanism of enforcement. We are not making a fuss of Article A. We have not grouped it with Article 14 or Article 12 point, and we are not saying that it is inappropriate to see whether people have married. We're just saying that is the only circumstance in which this will be permitted, and we want that to fall away, and we have no interest in enforcement for non-married persons. No interest. May I proceed?
12thly.
Takes us back, I think it is ultimately, isn't it? Yeah. Takes us back to a core concern. This is, we don't deny it, a socio-economic context. We don't deny that this, that is a socio-economic context, needs to be unpicked. The this that represents a control on the continuation of pensions for persons who are cohabiting is a matter out with the convention, and only, as it were, insinuates itself into the convention if it uses the Article 14 route. And there we see that a notional claimant, not before us here, would have a steep hill to climb. The married intended person is different. So the socio-economic context is both in the context of this judgment, those who cohabit or intend to cohabit or desire to cohabit, and those who intend or desire to marry. And we say, looking it full in the face, the essence test is one which of course embraces, as part of the redefined composite test, my lady, that I mentioned in answer to you, of course embraces the wider context. Of course it does. But it puts government on its guard. And in the light of the importance of the right to marry, the strong right, the fundamental right, the one to which the test of proportionality has not been automatically applied other than arguably through the prism of essence, the policy aspect of this, the economic and social nature of the policy choice, does not dominate, does not rule out, all being equal, the exercise of the right to marry. And in the language of Article 12, does not render it a non-attack on essence. Now, my lord, I know we've done the 12. Can I go to the next paragraph, paragraph 82?
Yes.
Because this to me is, in a way, where we are putting our argument, really, for you all to judge. Here we see they're all elided. The articles are all together. I'll get to 94, my lady, later, on the specifics of Article 12, but justification overall is a big statement by my lord, Mr Justice Fordham. And we see halfway down, in doing so, I reach the conclusion, by reference to the 12 key features and themes discussed above, that the Home Secretary has discharged the onus of justifying C9 in its retention. And then we go through the various explanations which embrace but go beyond Article 12. We say that that is eliding all of them. We say that, as it were, justification plausibly developed to explain some of the arguments has swallowed up the Article 12 argument within its grip and turned it into another ordinary proportionality justification case to which the 12 justificatory points apply. We say, and thank you, my lord, for the nudge to go through them, we say no. If you were remembering, we're discussing essence, if you're remembering that our composite test involves a different kind of approach, and even as I mentioned earlier, without remembering this point here, if we're talking onus, the state is on its guard with regard to Article 12 in the way that it is not with regard to the other matters that were argued and which we have discounted.
All right, but I think that then presumably we go from 82 to 92 to the end, which is
Yes.
where he draws the threads together in relation to Article 12.
Yes. And my lady anticipated this, and of course I needed to come back to it, because this is the wrong way round. I mentioned the tail and the dog. This is deciding on justification by reference to a range 12, matters which can, as I hope demonstrated, be unbundled to be shown to have a different application to the test of what is the essence of a right and whether it's been infringed. And having, as it were, done all that work, there's a sort of tidy up operation going on here. And besides, Article 12 is not breached. And I think the last part of paragraph 92, and again in paragraph 93, are against us, because I agree with you, my lady, if this was your implied, very polite, insinuations too big a word, suggestion, this looks like there's a little tick box, if I may be rude, exercise. Oh, I must remember that essence business, and I must remember that we tick those boxes about impairs or injures the essence. And the trouble is, the answers are too easy because they are taking their colour from an analysis of justification in which Article 12 has been left far behind, and which analysis, having been methodically completed, drives the outcomes in 92 through 94. We say in sum that not having applied the Article 12 material earlier or assiduously here with new tests of an approach rooted in essence, the judge has fallen into error. The tale of justification, which is a general tale applying to articles across the Convention, has wagged the dog of Article 12 and deprived it of its, I was nearly going to say essence, of its centrality in the Convention scheme as an article to which the Convention has a particular approach. And I think at the end of, if I may, paragraph 94, and I take the point about the composite question. I think I don't run away from it. But at the end of paragraph 94, he says, in the end, it may well be sufficient for the purpose of Article 12 compatibility to ask a composite question, as it is in the present case, in which disproportionality, arbitrariness, and injustice are part and parcel of the idea of whether the exercise of the right to marry has its essence or substance. We, and then etc. We absolutely accept that characterization of the composite question.
You accept that?
We accept
okay.
it. That is what my learned friend put, and we agreed. We accept, it would be eccentric that they are not part and parcel of the exercise of the right to marry in its essence or substance. We accept that. That's what we mean by a composite test. We don't mean, to be clear, because in a way we don't mean essence is the test of proportionality. We don't mean essence has no life of its own and it is a mere gateway to proportionality. We say essence has its own life. It is engaged in the reality of the circumstances around it, and we say it does that in a way that is particular to Article 12, reflects its strength, and requires a stronger proof before we can conclude that the essence of the right to marry is not impaired.
I think we need to know what you say about the earlier part of 94 before coming back to the what you might call probably the list in 93.
Yes.
But earlier in 94, which culminates in the section you just referred to, what's happening, I think, is that the test which had been suggested by Mr Edwards is rejected by the judge, and he says it's something more subtle than that, and then goes on to explain in the body of 94. Does that matter at all, given the last part which you've just referred to and have accepted, or does that all become verbiage?
I wonder whether you wouldn't mind just taking me to
I'm
extensions
sorry.
or two that you
I'm sorry. It's
particularly
just
in mind,
that. Where are we?
in order for me better to be able to
Yeah.
react. Because there's a lot in paragraph 94.
Of course. Well, he's considering a variety of things, including, for example, broad social policy, because he said Mr. Edwards submitted at the second line of 94. Mr. Edwards submitted that Article 12 proportionality is recognisably distinct, which he submitted meant that the four-stage proportionality discipline is not involved, doesn't involve latitude afforded to inferences with qualified rights, and you've covered some of this ground,
Yes.
and does not turn on considerations of broad policy, and that it asks whether the factors weighing against the measure outweigh the factors relied on by the state, a sort of list,
Yes.
comparable lists, a basis. And then the judge goes on to say that he thinks the legally correct position is as follows. And his test there in the body of 94 is different from a list in favour and a list against. And then he ends up with that conclusion in relation to the composite test at the bottom of 94. And I just wanted to know whether there's anything, having accepted that composite test question, whether there's anything in the body of how he distills what he thinks is the right approach in Article 12, in the centre of 94, that you disagree with.
Thank you very much.
I'm sorry, it's a very, very dense
but
paragraph,
it
especially
is
for somebody who's coming
pretty
to it very late.
Pretty dense. I'm given the opportunity to say that Mr. Edwards got it exactly right in his characterisation at the start here of paragraph 94. And as I recall, there was an emergent discussion about composite questions and so on in the course of oral argument. And what he's saying there is more or less the same as what I'm saying.
Exactly.
Look, it's different, he's saying. And then, so we take that as we're behind that, and that is our version of the composite, and I'm more confident now in my assertion that we're at one with the High Court submissions that were made by my learned, hospitalised colleague. But then we see, and this is a core to the argument, I think, we see that Mr. Justice Fordham said, well, no, come on, this is the way I see it. He doesn't say, oh, I'm going to react to that. And he says, look, this is the way we see it. And then if you go down a little bit, and he's talking about Lenin, and he's talking about considerations of broad social policy. And then he says, Lenin in the present case would fall outside Article 12. Well, as far as I recall, Lenin didn't engage particularly. I'm now at slight odds here, not fully recalling. So far as concerns the basic four-stage proportionality test, Article 12 does not lose sight of these basic contours of proportionality. There is a world of a difference, if I may say so, between not losing sight of basic contours of proportionality and applying a test. Our version, emboldened by Mr. Edwards' submissions at the start of paragraph 94, is that of course they're not lost sight of, but nor do they dominate. And it's a part of the test of essence that context is important, but a context against a background of the seriousness of this right. So we don't just go through the proportionality 1, 2, 3, 4, which we do with Article 14 in discrimination, and we say the habit of the ordinary approach to proportionality had infected the analysis of Article 12.
I'm grateful. That's helpful. Thank you.
My lords, my lady, if we've gone far enough, we could perhaps address my third of three
Yes,
questions,
please.
which would be a little shorter, I think, because some of it's been prepared. But I think we need to do it. We need to do it, if I may say so. And we, you'll recall, we were fans of Mr. Justice Fordham, now we're critics of Mr. Justice Fordham, and now, thirdly, we're saying here's what should have happened. And we've anticipated quite a bit of this already, my lady, my lords, in the discussion about the composite test and so on. And I don't know if I need to spend a lot of time on it. What we do have is an article by the President of the Court of Justice, which is in the authorities bundle at page 356 to 370, and therefore available. And we were looking at how best to present essence to my lady and my lord. And here is a very useful, if I may say so, summary. But I want to go close to the end of it first, because let me just spend a second. Fine. I'm going to give you what I believe is the correct analysis, if I may, borrowed from the President. But he says, I'm on page 788 of the article, not the bundle.
Yes.
And I'm looking at a paragraph which starts, it's the second substantive paragraph. It is worth noting. Are we with this? It's worth noting. Now, this bears on a sort of critical engagement that I allowed myself to develop a little earlier. But here we have, now I know there's institutional rivalry, and this is the President of the Court of Justice of the European Union. And he does, however, say, and I think this is true, it is worth noting that the case law of the European Court of Human Rights has not always followed the method of analysis employed by the CJEU, to which I will turn, and which makes sense of essence and how to apply it. Now, not always doesn't mean has never, you know. So I'm creating a picture of a diverse range of authorities from the European Court of Human Rights, from which it is not always easy to distill, as it were, a coherent line. And in the past, incorporated the concept of the essence of a fundamental right into a proportionality assessment in the past. So we have here a very fair presentation by me, I hope fair, which is saying what I'm going to take you to, and this is why I've taken you to this first, is an intellectual engagement about what essence means, the history of which is presented by Mr. Judge Lennox, and which makes sense of what we've discussed, but is not consistently deployed in the Court of Human Rights. So, as a little adjunct, you'll all know, of course, that Section 2 of the Human Rights Act gives you, you know, relative freedom. I mean, we're not going into 150 court cases from Strasbourg to try and work out what the consistent thread is. And we're asking you to think afresh about essence using the authorities we've suggested. Now, what does it mean? If I may go back, having given you that frank caveat from President Lennox about the case law of the court, what does he think it means? Well, he says, I'll take you through just a little of this, then I may well stop. If we go to page 780, where does this essence thing come from? He says it can be traced back to German basic law, top of page 780, and then you have all these countries with all the words that describe essence, and it found itself, this is material, into the Charter of Rights, which you'll be familiar with, now no longer, of course, post-Brexit, part of our legal system, or so it never was really proper. But anyway, it comes from there. And then he has a second paragraph, second substantive paragraph. In the same way, although the obligation to respect the essence of a fundamental right is not expressly recognized in the European Convention on Human Rights, it can nevertheless be found in the case law of the European Court of Human Rights. Now, and we've got a number of cases which we've not. I don't think we've got any of these. We don't need, I mean, we didn't want to inundate.
Sure, we don't need them.
My lord, we didn't want to inundate you. We took a very practical approach to this. But it's sneaked in as an interpretive device, exactly what I said about Article 12, a control in Article 12, but not the same as in other articles. And then we see a little bit towards the end of that page, before we go into the footnotes, a European a Court of Justice thing. What does it mean? It pursues an objective. This is something which tranches on a fundamental right, recognized as legitimate by the EU legal order that does not constitute, with regard to the aim pursued, disproportionate and unreasonable interference, undermining the very substance of that right. Now, this is important distinction between, as it were, if I may say so, kind of ordinary intrusion into a right, and an intrusion into the very substance of the right. So, in fleshing out what we mean by essence, we become aware that, of course, there are background facts concerning individual cases that determine what essence means, but it's about the very substance of that right. And then we get, and stop me if I'm whizzing through, we get to the leading case on page 781, which is in the bundle, at page 228, occupying a fair bit of the bundle, 60 plus pages. But we've got the distillation from the President of the Court of Justice of the European Union. A seminal judgment, he says. And I want to take you, I know this is the European Court of Justice. I do appreciate this is out with the convention, but it's central to understanding what essence means. Because we have a summary here by the President. Halfway down, the paragraph starts moreover. No, sorry, excuse me. The paragraph starts against that background. Against that background. And there is this, he argues, in the light of the seminal judgment of Schrems, the concept, it's a sentence that starts as in part B, the essence of a fundamental right implies that every fundamental right has a hard nucleus that guarantees to each and every individual a sphere of liberty that must always remain free from interference. And then, interestingly, that nucleus, next sentence, may not be subject to limitations. May not be subject to limitations, quoting Professor Trimidas, the principle of proportionality. Now, it's said 3 lines down, a sentence that starts, as the Schrems judgment shows, and this is the essence of my earlier argument, I'm bound to say, a measure that compromises the essence of a fundamental right is automatically disproportionate. Nevertheless, the fact that a measure respects the essence of a fundamental right does not automatically mean that it complies with the principle of proportionality. Now, I'm going to go back to something I said earlier in reply to all of you, really, and my lady in particular. The essence test embraces a composite range of factors, but proportionality is a part, but in a different way than the 4-stage proportionality test. And it's only part. And the test takes into account some, but not all, of the justificatory points made by Mr. Justice Fordham that we've gone through. And once you find the essence is breached, which essence test embraces compositely much of what we've discussed, once you find, and the onus is on, as it were, people to prove that it's okay for strong right and so on, once you find that, you do not, and this is where I was earlier, and I look it in the face, you don't go on then and say, but though the essence of the right has been infringed, has been violated, is it proportionate? That is a contradictory position. You cannot say that the essence of a right has been destroyed in a particular case, and yet it's a proportionate destruction. Because essence is not the same. And we say, just let me finish this little swing. We say that with suitable allowance for the fact that Article 12 is an unqualified right, with suitable allowance, that essence has to bear some of the burden of the context around it. We say that is correct. But I think you may have wanted.
Yes. I think you referred earlier, it may not have been your word, but the impression I got was that you were describing Article 12 as unique in a certain respect.
Yes.
Are there any other articles in the Human Rights Convention that should also, in your submission, be interpreted in this, as it were, essence manner?
Yeah, the President says of Article 3. I haven't got the reference.
Yes, but which, I mean, could you just
Yeah.
tell us illustratively, not
Yeah,
comprehensively, which other articles
Yeah, there's no test.
benefit from this?
A breach of Article 3 is an attack on its essence. So there isn't a debate. If you are shown to be subjected to inhuman or degrading treatment or torture.
Yes, well, I'm just making a list at the moment.
Yeah, right. I'm with you on Article 3.
Yes.
Where, just to expand ever so slightly, where there's no saving grace.
But that's been described as an absolute right.
An absolute right.
Yes, but
An
Article
absolute.
12 hasn't been described.
It has
as
not
absolute
been described as an absolute right.
It's been said that it isn't.
It's a positive right which requires state action.
Yes,
And-
but
and-
apart from Article 3, any other rights?
I
that-
think Article 4, I doubt there are situations where
Slavery enforced.
enslavement could
Yes.
be thought to be something which could be done without attacking the essence. I'm thinking the right to liberty, no. Fair procedures. Article 6 is a complicated one because once they've decided that there is no fair trial, that is, as it were, game over. But the discussion of what is composed of a fair trial is one that takes into account.
I'm just
the range
asking
of
because
materials.
Nick, I think we'd obviously, if we were attracted by your very fundamental reconsideration of how one was to go about this under Article 12, need to be conscious at least of the breadth of your submission in relation to other parts of the convention. And,
Yes.
you know, what footprint your submission has elsewhere in the convention that would be being revisited.
My on my feet submission, and we may hear from my learned friend on this, is that it's on its own. That I'm not arguing that the test of essence in Article 12 has crossover effects. I'm taking you to Mr. President Leonard's because it's a useful exposition of essence and putting the flesh on, as it were, essence. But a moment's consideration can show you, for example, that Article 3 doesn't bother with essence because if you can establish it, as I said much earlier this morning, you're in, because the nature of it is essence. Article 14 different, Article 6 different, ordinary proportionality creeps in. Article 12 is where essence does the work of limitations, which are not set out on their face, and which is not done by the principle of proportionality, as one finds elsewhere. And therefore, essence does a little bit of the composite work of taking into account this and that, but it does so against a background of Article 12's strength. And so Article 12 is purposefully designed to be unqualified in that way, but common sense and the rules required by the nations to regulate it suggest there are limitations, and the limitations occur within the context of essence.
It may be that the final sentence of the judge's paragraph 94, beginning "in the end it may well be sufficient." You said that you were content with that formulation, and it may be that Mr. O'Brien is as well. It doesn't seem hugely controversial to me, but we shall see.
As long as the wider issues are seen as being dealt with in the context of the Article 12 overriding test of essence, we're very comfortable with. We are not comfortable where it becomes just another way of describing the ordinary proportionality test. And to that extent, we're content because they're part and parcel of the idea of whether the exercise of a right has its essence or substance impaired. They are not the be-all and end-all. Of course, they're part of it, but they're not the be-all and end-all. And the justificatory points made in the course of those long 12 paragraphs need to be tailored to the strong right Article 12 protects.
Okay, we've got that. Now, it's coming up to 5 to 1. You said that the journey would have 3 stages.
Yes.
Have we got to the end of stage 3?
I think I'm going to get to the end.
Yes.
I'm going to end with a little peroration about my clients, and then I'll sit down.
Yes,
so I'll
please
begin
do.
with a lunch break. And I just ask you to have a look at Schrems and Cole-Leonard's. But we've made our pitch that essence has a coherence, and it's a coherence that is captured in that paragraph 94. As long as we know it's specific to Article 12. We've left out, my last remark, we've left out our clients. And in a very nice way, I would direct you to the Mr Justice Fordham's lived experience, I think you may call it, paragraphs 33 to 35. Mr Justice Fordham was, in a way that we were, I have to say, very pleased with. He was alive to the concerns of our claimants, to push them through the High Court into this court. There had been earlier confusion about which court. This has been going on a long time. And what we want to, as it were, recall, though my lord and lady are well aware of it, is that so far as two of our claimants are concerned, the financial inhibition to the loss of the pension is such as to give them, sentence them, be dramatic and melodramatic, to a life sentence of isolation and, I'm bound to say, duplicity. Now, there was a quote from Mrs. Maid about, what was it, isolation or economic security. I'm not sure that's true, because it's economic sustenance requires isolation. And although it's not germane to this case, and I'm not making it such, having to fill out the form and getting people to say that you're not living with somebody and the chap's not been around a lot or enough to warrant the intrusion. It's not about the right to marry. I've said that earlier, but it's nevertheless embraces the test within it, our claimants. And I've not mentioned children. They're not part of the case. We're resisting the tagging along of children, but there are, in these cases, I have not taken you to the facts, but what happens in some of these cases, I'm not alive to the exact circumstances here, is you'll have one of our claimants or a claimant in this situation, and they develop a relationship with somebody who's jolly helpful and who may well be doing very good work with children that have been left without a father or a mother. It's not material. And the life of duplicity, which we've come across in the course of preparing for this case, can sometimes be very corrosive of an entire family unit. I'm not making a sort of romantic claim based on children's rights, or not at all. But I'm just saying that in the balancing that we have been seeking to achieve intellectually here, we have sort of risked, and I've sort of risked, forgetting the intense disruption of the lives of claimants, whose lives have already been disrupted by death, whose children, if there are children, may well find the inability to frame an ordinary, in inverted commas, no disrespect, family relation with mummy's friend or daddy's friend. Really inhibiting. It was enough to cause one of our clients, as you know, to just cohabit and then marry. He could do it. Two of our claimants can't. And they're the only three people with whom we have a concern in court today. And that is, I think, that.
We're very grateful to Professor Gershed, particularly for having stepped into the breach. Thank you very much.
Thank you. Thank you, my lord. Thank you.
Mr. Reed? Sorry, Mr. Fordham. I say sorry.
Well, look, there's an issue that my learned friend has raised that may involve some submission on the Metropolis Police, but I'd like to discuss that with him over lunch.
All right.
And take some instructions.
Yes, that's fine. All right, we'll rise till 2 o'clock.